All right, good afternoon. We're going to go ahead and get started. Just as an announcement, House Bill 922 by Representative Vance, that is going to be off the calendar per the request of the sponsor. And we'll go ahead and start with Representative New, House Bill 1056. Good afternoon, whichever.
Good afternoon. Thank you, Chairman. Thank you, members. I think everybody else has taken a nap. They're in the food coma. I appreciate the opportunity to talk to you about House Bill 1056. We're working with LC 570050. Currently in Georgia, there's a lack of substantial penalties for selling drugs to individuals of any age. While the maximum sentence is 5 years in prison, it's often probated, resulting in no real consequences. This bill enhances penalties for adults defined as 21 years old and older, selling drugs to minors defined as 14 years old and younger. Offenders would face a mandatory minimum sentence of 5 years in prison without the possibility of probation, deferral, suspension, or stay. The court does retain the discretion to deviate from the specified mandatory minimum sentence if all parties involved agree. That includes the judge, defendant, and the prosecuting attorney. The reason for this bill is the average of 22 U.S. teens ages 14 to 18 die every week. 5 a day, average, in the U.S. This is a classroom full of kids weekly dying because of drug overdose. And it's because we're not doing enough and we're not tougher on the ones doing harm to these little kids. The current state of the drug crisis, with fentanyl claiming the lives of our kids, highlights the urgency of taking action. We have to do something bold to save them. By safeguarding our children from drug use and ensuring they do not start down this destructive path at a young age, we can foster a healthier future generation. This bill serves to send a clear message to the adults who are targeting our kids. Selling drugs to minors will result in significant prison time. And by implementing these enhancements, we hope to deter individuals from endangering the well-being of our minors. That's what this bill does. That is the heart of this bill. And I will take any questions you have at this time.
All right, any questions? I don't see any questions, but we do have one person signed up, so I'm going to, actually, we do have Representative Mogul.
Thank you, Representative New. Just a question that just popped into my mind was, what if a minor is selling to a minor? Then what?
So we're not interested in kids selling to kids because kids are going to make bad decisions. We're wanting the adult that is targeting these kids. And I'm not interested in the 17 and the 18-year-old sharing a joint at a party because, again, kids are going to make bad decisions. This is a distinct separation of adult to minor. So the adult is 21 and older, minor is 14 and younger. The reason I chose 14 is because that is when they start to die. And if we can stop this destructive behavior early, then hopefully we'll give our children a better future and a chance. Thank you. Thank you for the question.
All right, thank you. Maisie Lynn. Representative New. Representative New, can you just scoot over a little bit? Thank you.
Of course. Good afternoon. Thanks for hearing from me on this legislation. I have spoken briefly with Representative New, and just in full transparency, she is not a fan of the suggestions that I'm bringing to you today. Nonetheless, here I am. When you look at 161330, this 1056, of course, would modify, I believe, M, if memory serves. But if you look past it, current subsection K is an effort to penalize people, adults, who use children to help them with their drug drug distribution systems. So the same idea of manufacturing, distributing, dispensing. If someone hires, solicits, or engages an individual under the age of 17 for helping them in that business, they are subject to felony prosecution, and if they're convicted, the punishment is 5 to 20 years or a fine not to exceed $20,000 or both. Our hope is that you all might consider mirroring that sort of sentencing structure in 1056. Whether it's at 20 years for the ceiling or 30 at this point is less of an issue to me than the fact that 1056 is a mandatory minimum sentencing scheme with the escape valve requiring the consent of the state. And I know you all have heard me say this before, but these escape valves that require both agreement by the defense and the state truly are a mechanism by which you are handing judicial discretion to the prosecution. I can promise you there's not a defense attorney worth their salt that is not going to agree to a lesser sentence or departing down from a mandatory minimum sentence. So by requiring that agreement, you're taking this sentencing out of the hands of the judges, handing it to the state, and we would just ask you to reconsider that in this particular code section and mirror this other language that also intends to protect children just from a different angle within the drug distribution channels.
All right, thank you.
course.
And there are no questions. And we're going to keep this as a hearing only, Representative. Thank you.
Thank you. Thank you, committee. Appreciate your time.
Representative Maynor, House Bill 1136. Before you start, I just want to recognize Judge Gary Jackson from Atlanta Municipal Court. Thank you for being here. Thank you. All right, go ahead.
Thank you, Chairwoman, Madam Chair, and thank you, committee, for hearing the bill today. I've brought this bill to you a few times, and there are other people here that will speak on the bill. In the past, over the past few years, I have come and I've given you the statistics on what is stalking. I've explained to you how it impacts people. Stalking is one of those crimes where the person that is the stalker gets quite creative when they are stalking you. They learn everything that they can do. They'll go right up to the point of crossing the line of where they're not stalking you. And I will not go into personal examples because I am the victim of stalking. But with me being the victim of stalking and it being public, that means that women and men from across the state of Georgia are contacting me about them being stalked. And so if you see the two signers on this bill, they have also had constituents to reach out to them because their constituents are being stalked. And what does this bill do? This bill simply says you have to still establish that someone has stalked you. When someone stalks you, it's just not one incident, it's multiple incidences, and the judge will determine if the multiple incidents are indeed stalking. The problem that's happening, though, if you get a restraining order, my restraining order was a 3-year protective order. A year from now, if I get a restraining order and my stalker decides to stalk me again, even though it's a violation of the restraining order, it is not considered a new incident of stalking. This simply says after you have been charged with stalking and found guilty of stalking, if down the road, if you continue to stalk someone, this is now a new incidence of stalking. And that is the gist of the bill.
So currently, if you have been convicted of stalking and then you go ahead and do the same thing, you're saying that it's, even if it's a completely different scenario,
I will give you an
that
example.
prosecutors are not prosecuting it?
That is exactly what I'm telling you.
officers are not arresting him?
That is exactly what happens. In fact, you can tell a police officer that you have a restraining order, that you are being stalked, this person has done X, Y, and Z. They do an investigation. Well, actually, sometimes they don't even do the investigation. They just write it up as an incident report. And unfortunately, the victim has no idea it's an incident report until after 3 or 4 occasions have happened, and the victim is going to the court system saying, well, what happened? What are you doing about this? And the victim will find out the officers did not investigate. They just decided to do an incident report. I want to give you an example, though. In my case, stalker went to jail, served time, got out of jail, stalking again, and the prosecutor said they already served their time for stalking you. And so now you have to now establish a whole new set of incidences of stalking. So in other words, forget that they served a year in jail, forget everything that happened in the past. Now this is the same person, but we're going to act like he's a brand new person stalking you, and you have to establish another pattern. This bill is saying the pattern has been established, and after time has passed, it's no need for the person to need to establish the pattern again because it has been established. This is a new incident. Within the law right now, if you just stalk someone, that is a misdemeanor. You have to show a series. You just keep doing it over and over and over. That's when it becomes felony aggravated stalking. So each time, so this bill kind of refines that language. Each time someone commits another act, once it's been established it's stalking, it's a new act versus just piling it on top of each other. I was telling someone here from the commission that's going to speak to the bill, one thing about stalkers is they get crafty. And so this bill is trying to be crafty with the stalker because they manage to find ways to get around it being called stalking. And a very good example is the one I just gave you. You can serve time in jail for stalking, stalk the person again, but the prosecutors will say, well, this is a brand new case.
Okay. And I have another question. Line 28, I saw that you struck the other than the residence of the defendant. What's the purpose of that?
Can I see? I'm sorry, I ran in here.
Can you give me a copy?
Thank you so much. Which line is it?
28.
So starting at line 26, for the purpose of this article, the term place or places shall include any public or private property occupied by the victim. Where the victim lives, whether we're just trying to make it clear it's where the victim lives. We don't want any other additional language to go past that. It's just if the victim is at a place, then for the purpose of this article, we're just trying to make it clear. It's where the victim is.
Okay, I'm going to think a little bit about that. Any questions from the committee? All right, and I'm going to bring up Kylie Elliott, please. Good afternoon. If you can state your name and who you're with.
Yes.
Thank you.
Thank you. My name is Kylie Elliott, and I'm with the Georgia Commission on Family Violence. And we're the state agency here in Georgia charged with addressing the issue of family violence in Georgia. So this issue is extremely important to us because stalking is a significant problem in Georgia as it relates to intimate partners and other individuals as well. So I am here to express that the commission is supportive of this legislation, and then just to share a little bit of thoughts on my experience dealing with victims that, or helping victims that are dealing with stalking situations. In Georgia, 1 in 3 women and 1 in 5 men experience stalking in their lifetime. That's actually higher for men. Higher for men than the national average. So men in Georgia are experiencing stalking at an even greater rate in Georgia than nationally. And it's also important to note that 82% of stalking victims are stalked by someone they know, and 72% of victims that are stalked are threatened or experience physical harm from their stalker. So stalking isn't just harassment, and it isn't just a nuisance. It's a serious danger. And the last statistics that I'll share is that 76% of women that are killed in this country have experienced stalking in the year prior to their death. So those are really serious statistics that really elevate the level of this problem. So I want to, express that our support for that and anything we can do to strengthen our stalking laws. If I could speak to that item you questioned about on line 28, there's been similar talk over on the Senate side with regard to stalking in the residence of the victim. Well, there are situations where victims are experiencing stalking, surveillance, and harassment in a shared residence with another individual. So what we want to say is that it matters where the victim lives. It doesn't, that a stalker or an abuser doesn't have that as an escape clause from the actions. It's a way that they can protect themselves. There are plenty of times in Georgia where intimate partners, for example, will separate legally but not physically outside of the same house. Maybe one person takes the basement and one person takes the upstairs. And when someone finds surveillance devices in their bedroom or in their bathroom or things like that, or on their computer, those things prevent them from safely leaving. So it's important to know that stalking in intimate partner situations happens both before, during, and after the separation. And those kind of behaviors being allowed to continue only forces victims to return and stay in dangerous situations. And so that's one of the really values of that being included in this bill that we want to do. Stalkers are relentless. They are crafty, as Representative Maynor said, and they use all sorts of different tactics. So if we cause one roadblock, they tend to find another. For example, if we say that they can't call a victim anymore, they'll stalk by proxy, meaning they'll use another individual, or maybe they'll go to the victim's family and start stalking them in those kind of ways. So we find that they're extremely effective. And so by that, it's really important that we have strong legislation that cuts them off from being able, really establishes a barrier. Because what's so hard, and the last thing I want to say is in reference to Representative Maynor's statements about how having to establish a whole new pattern is a problem. Because, in our stalking laws, a pattern is 2 or more incidents, right? It starts to establish a pattern for stalking. But if you've already got the pattern, to have to recreate that, in no other area of our law do we really require our victims to prove their own cases like we do in stalking. In stalking, we tell them, prove to us you're being stalked. Bring us the evidence. Do all the work for us. And we need to really support our victims in that way, that we're not going to allow that, and that if we've already got it, because so many of the actions of stalking are non-criminal. For example, it's not criminal to send a victim flowers, right? But if the abuser had told his victim, on the day you die, you'll get a beautiful bouquet, and then she receives flowers. That's a very terrifying thing, but it's not in and of itself a criminal act until you connect it to the course of conduct and the pattern. And so that's why it's so important that these pieces be taken individually and separately, and that the pattern be established.
Great, thank you. And you don't have any questions. Thank you.
Thank you.
Maisie Lynn.
Good afternoon, Maisie Lynn Gerton from the Georgia Association of Criminal Defense Lawyers. From what I've heard today and what often is discussed when bills like this come before the General Assembly, it continues to raise a question about the education of our law enforcement as well as our magistrate judges with respect to the way that these crimes are being enforced or not being enforced. And I guess I'm not convinced that additional changes are going to change that behavior and improve it from where it is today. And we have had the conversation a couple of times over the years since I've been here around line 28, which is this idea that you would remove the residence of the defendant. The way that the language is in current law, it's essentially an exception that a person cannot stalk another person in the first person's home. And I realize, as has been described here, that there are difficult situations that can happen in these stalking contexts where people are sharing a residence and it's difficult to become unenmeshed. At the same time, the breadth of this removal would mean that if I own a home, it's my home outright, and I'm accused of stalking, let's say I'm even arrested for stalking, and I go to jail. When I'm released on bond, as is often the case, I would have conditions on my bond to stay away from the alleged victim in my case. If this language is taken out of this code section, I can't return to my own home that I own and pay a mortgage on if the person who's made the accusation is residing there. It's a difficult problem to address, but I would think that we would have concerns that we would be foreclosing someone from returning to their own home in that kind of a situation. Different matter if it's a shared home, 2 people on the title, 2 people on the mortgage. I think that's I would have less to say about that. But this does not, as it's drafted now, it does not foreclose the possibility of a person, it's their castle, right? We talk about that in certain contexts under this dome, but then today the idea would be to remove that kind of protection, that place that is theirs, their safe hold, their foundational property in the world. And that is a concern to us. It remains a concern to us over the years. And we've offered in the past to come to the table to try to find some way to be more surgical about how to carve out that sort of concern, but it just hasn't ever come to that. We would continue to offer that, and just want to bring that to your attention. With respect to the need to reestablish the pattern, again, I really wonder how much of that's education. I don't believe that the law as it stands is vulnerable in the ways that it's being applied in Representative Mainer's case. I can't speak to that beyond the fact that what is on the books should be sufficient if it's being properly applied.
But I've got a question.
Yes.
Whether or not we change this language, currently all bond conditions have no contact. And so the situation that you describe where if 2 people are living together or, the person is staying there, he's not going to go back to his house either way because of the bond.
Well, I think,
So-
for me, I guess this takes it to a different level. I use the bond condition as a kind of a ready example, but this would mean that you could predicate the actual crime on behavior that happens in your own home. I know it's difficult sometimes for the people that are the target of stalking to remove themselves from a residence. We can't expect the homeowner to be removed from the residence. like I said, I think it requires something more surgical. The idea that you can be accused of, there are lots of crimes that we are accused of doing in our homes, right? There are batteries that occur in our homes. There are other things that happen. It's not that I'm trying to say that a home shouldn't be a place where a crime can happen just because you own it, but because of all of the nuances within stalking and the idea that it is determined by the location of the victim, to some extent, the alleged victim in these cases, again, they don't always have the choice to, but some have a choice to not return to that residence that is not theirs, that they are not on the mortgage for, the title for. And because this crime is predicated on the location of that person, really puts the homeowner in a difficult spot. And the bond condition, is just an example, but I agree with you. It happens in other cases too.
So is it your suggestion to leave that language?
Until something more precise could be developed, yes.
Okay. All right. Any questions? No questions. Thank you. Ms. Weaver. Welcome back.
Thank you. Thank you for recognizing me to speak, Madam Chair, members of the committee. You may recall, for those of you who were in attendance last year, that's me right there standing beside Senator Jackson across the street there at the Coverdale Legislative Office Building. You may recall wanted to share a similar sentiment with line 28. Something I think was missed in the conversation, Senate Bill 63, this might sound familiar. If Governor Kemp chooses to ratify that measure, there would be no unsecured or unsupervised judicial release for stalking. Stalking is a mandatory hold offense if that becomes law. So if a criminal defendant is alleged to have committed a crime of stalking, when they get to jail, no bond on the spot should that become law instanter. With that having been said, I think that what the legislature would be doing if the legislature chose to adapt that language in its current LC rendition is you would be creating inconsistent public policy even within the official code of Georgia annotated itself. I know that it's not part of the bill, but I would invite the subcommittee to consider Georgia Code Section 16-11-62, paragraph 2, subparagraphs capital B and C. Those two subparagraphs within that paragraph of that code section specifically authorize the rightful owner or occupant of a residence to install surveilling devices on or about the premises and approach of the residence. Placing an individual under any type of electronic surveillance is one of the elements that gives rise to the offense of stalking, as is predicated under current law today. So you would be creating inconsistent public policy. For example, Representative Leverett was nodding his head at me. If Representative Leverett, for example, if I may, if you owned property, if you owned a residence. No. Oh, thank you. Sorry, Madam Chair, but if you own a residence under the law, or if any of you own a residence, you could put those systems up. If I came over, how dare you stalk me in your own residence? Just like I explained to this honorable subcommittee last year, how dare you have the nerve to follow me upstairs and ask what I'm doing or into your kitchen? How dare you ask what I am doing in your home? How dare you stalk me or anyone for that matter? I just think that it's a horrible, awful. I'm sympathetic to the plight of the author of this legislative measure, but I'm glad that the chair and members of this subcommittee share those same concerns, that would be not only inconsistent public policy, but that would be bad public policy to say that someone else has more power than the owner in the owner's own home. I don't think it works that way. And if you were to splice that and say, well, in this instance it does because somebody's feelings were hurt or somebody felt through their emotion or through their sentiment, and maybe even arguably so under some isolated cases perhaps, I dare not venture to say to be disrespectful to anyone who has been honestly victimized by the wrongful actions of another. But when we make public policy decisions, I would ask that this General Assembly not condition those to heartstrings at the moment. And this is especially true based on the Counterman versus Colorado case that the Supreme Court ruled on. A very bizarre mix of justices, 7-2, ruled that when it comes to stalking and harassment, the thoughts and feelings of the alleged victim are not material. The government has to prove the intent of the actor. And statutes that are set up in such a way, not saying Georgia's is or isn't, but to expand it and say, well, the victim felt that they were being harassed, or the victim felt that they were being hurt, or the victim felt emotional distress or mental anguish. It's not how it goes. The Supreme Court's ruled that the government has to show that the actor meant to cause that harm. And looking at the statute, I'm not saying that it does or doesn't, but what I'm saying is, and based on some of the examples that were earlier proffered to the committee, when you put that and then you couple it with the fact that those acts could even occur in one's own home under the current LC rendition, I just think that there's just too many obstacles there. And in approbation of the previous speaker, Ms. Maisie Lynn Gerton's comments, it's just not surgical enough to pass muster, and I would ask that this honorable subcommittee not advance this measure in its current LC rendition given those considerations.
Thank you. Any questions? Thank you. Representative Maynard, do you want to respond? I'll give you some time to do so.
Thank you, Madam Chair. The nuts and bolts of the bill seem not to be what the opposition is voicing. So if it's the will of the committee to not have on line 28 other than the residence of the defendant no longer strike, I am happy to do that. The nuts and the bolts of the bill really is to prevent victims from being stalked over and over again for years at a time. If you look at the flyers that I passed out, you will see in that data that most victims are stalked. I think it's like 12% of victims are stalked 5 or more years. That is a long time to be surveilled. That is a long time to be harassed. And oftentimes it never ends. And so with this bill, we're hoping to cut down on that. I will say that I have spoken to the previous speaker. This language is drafted based on all of the suggestions that she gave. And so I was happy to see that it seems that line 28 was the only stickler. And so if line 28 is the only stickler, I would be happy for the body to amend as appropriate. The other thing I would say for line 28, another suggestion would be, if it said other than the residence, if it mentioned something to the fact of if it was the defendant was the homeowner, because one thing that is also clear when you have a restraining order, the victim also should be trying to stay away from the person that is being stalked, right? And so there are sometimes where a man or a woman may be doing things out of emotion to go get a restraining order, and they violate the restraining order themselves. This bill is not about that. This bill is not about a passionate person that technically is not a victim because they're violating the exact restraining order that the judge gave them. This is for victims that are seeking relief.
Thank you. And Chairman Leverett has a question.
Thank you, Madam Chairman. And I apologize again for being late here, but I gather is your primary purpose in the bill to prevent sort of a pattern from merging into one long ongoing violation as opposed to having separate acts you could act on?
Absolutely, because right now if you stalk someone, if you show the pattern, it's a misdemeanor. If you show the pattern again, it's aggravated stalking. The problem is, if someone's being stalked, it continues to happen for years, and it does not serve the victim justice if the acts continue to just pile on top of each other. That is the purpose of the bill.
And so, one other follow-up, Madam Chairman. So I guess at times are those repeated acts over time just construed to be one ongoing act of stalking, and therefore there's only one penalty, one bond, and one order?
Yes.
Okay.
And the example that I gave is stalker goes to jail, stays in jail for a year, comes out of jail, continues to stalk the person. The victim goes to the prosecutor, or reports it to the police. Once it goes to the prosecutor, then the prosecutor says, oh, well, they actually served time. They are no longer a stalker. They have to show a brand new instance. So this says the instance has already been shown. They've served time, and they're continuing to do this. And as the commission stated, it is burdensome for victims to try to collect the evidence. Because once you've been stalked, you then become crafty. You then figure out, okay, they're going to do this, and so now I have to collect this so I can make sure I'm showing the prosecutor this. That is coming from an educated person. The lay person may not have the capacity to do all of that.
Thank you. Thank you, Madam Chairman.
All right, thank you. All right, any motions?
Chairman, I make a motion to pass.
Okay, do we have a second? Okay, we have a motion to pass and a second. Do we have an amendment?
Can I amend my own motion now, Chairman?
Yes.
I would move that the strike-through on lines 28, other than the residence of the defendant, the strike-through be removed so those words would remain in the statute.
Okay, sorry, I didn't have your mic on, but I think everybody heard. So Chairman Leverett's amendment will leave other than the residence of the defendant wording on line 28. Do we have a second on the amendment? Okay. All those in favor of Chairman Leverett's amendment, say aye.
Aye.
Those opposed, same sign. All right, so the amendment is adopted, and all those in favor of passing House Bill 1136 with the amendment, say aye.
Aye.
Those opposed, same sign. All right, passes. Thank you.
Thank you.
All right, last bill. Representative Reeves, House Bill 926.
Thank you, Chairwoman Hong and members of the committee. I am back on House Bill 926. This is LC 394238. This is a shorter bill than you saw a few weeks ago, and Representative Maynard, my co-sponsor, I believe, is joining me up here. Shorter bill than last time in that it does not include the certificate of good conduct. We were not able to get the Georgia Sheriff's Association signed off on that provision of the bill. To date, we are still working on that, and hopefully that will change over time, but this just addresses the driver's license portion of the bill. There is one change that we received a request for today on page 2 of the bill, lines 22 through 30, to add that back in. Therefore, all of page 2, no strike-throughs. So add in lines 22 to 24, and then 28 through 30. The Sheriff's Association looked at the bill closer once it did not include the certificate, and they asked for 28 through 30 to be added back in.
And then when we reviewed this further, we said 22 through 24 ought to be added back in as well. So that is one amendment. As you see in your folder, I'm thankful that the Georgia Chamber did endorse this bill. As they note, if you lose your driver's license, you're probably going to lose your job, and we have a huge need for workforce. We did not get into DUI issues in this bill. This is for offenses that happen in municipal court for a variety of reasons that don't deal with traffic safety or have a nexus to DUI or child support, those things that you really need to get people's attention for. So the bill just has a focus on encouraging defendants on low-level offenses to engage with the court promptly if they have a need to miss court, and it gives the courts latitude to deal with their defendants so that there's not a protracted loss of a driver's license. I thank Ms. Shavonda Leslie with the Department of Driver Services for going through this bill. There were changes made previously to this driver's license portion based on feedback she gave. And I believe Judge Jackson with City of Atlanta Municipal Court is here today to talk about the caseload that City of Atlanta Municipal Court and other municipal courts face around the state that would be aided by this bill. And I thank the Social Change Organization, Mr. Belcourt, for the work they did on their certificate. They are, I believe, supportive of the remaining part of the bill, not including the certificate. They are trying to get people to work here in Georgia, and appreciate the work they did on the certificate, and we'll stay in touch with them on that. But I would ask you to do pass the bill as amended, and with that additional amendment of adding those provisions back on page 2, and would yield for questions. And I believe Judge Jackson's behind me ready to speak.
Okay, and just to confirm, we're going by LC 394238S.
Correct.
Is that correct?
And that does not include the certificate. That is a 10-page bill that just addresses the driver's licenses.
Gotcha. Thank you, Representative. Any questions? All right, I will, Chairman Leverett.
Just want to clarify that when we get to that point, the amendment you desire is just to, everything in section A1, lines 22 through 30, all the strike-through would be removed. You keep all that text.
That's right.
Okay.
Thank you.
All right. Judge Jackson, I'll have you come. Thank you for being here.
Thank you, Madam Chair and Madam Leader. I first want to say thank you for this opportunity. I'm here as an individual judge, not on behalf of my court or my counsel, but I wanted to give the committee members essentially the lay of the land and failure to appear situations that arise not only in my court, which is the busiest traffic court perhaps in the country, but all throughout the state. Failure to appear FTA is by far the #1 administrative problem we have in our court, by far. Every Monday and Tuesday, I'm one of 4 or 5 traffic judges. At 10 o'clock in the morning, I have an entire calendar devoted to FTA, at least 30, usually 40. So we're doing 500 a week, and we cannot catch up to the backlog. And the backlog has nothing to do with COVID, because we have no backlog because of COVID. And up until recently, my hands were completely tied. Senate Bill 10 passed a couple of years ago that gives me some discretion to give back a driver's license. But this is how FTA works. Remember, in Georgia, most traffic tickets, other than the camera tickets, are criminal offenses, misdemeanors. Most of them carry a fine, up to 12 months in jail, any reasonable condition of probation, including suspension of license. When you get a ticket in the street and the officer puts it in your hand, you're being served with a criminal summons. And right above the signature of the ticket, after it tells you when to come to court, if you don't come to court, your license gets suspended. And it stays suspended forever. I've had them 27 years later. They're first now coming into court. I had one earlier this week, 2019. I've had one driver with 17 suspensions. So this is a tremendous problem. There are very few legal excuses to miss a court date. Very few. Work and school are not one of them. You're sick, you're in jail, member of the military with military orders, a member of the General Assembly or certain aides, you're a defendant, a witness, or a jury on a grand jury. That's it. work, school, weddings, funerals, confirmations, bar mitzvahs, unrefundable airline tickets. No excuse. Up until Senate Bill 10, if you missed a court date, even with a legal excuse, unless your case was completely over in the courtroom, you entered a plea or the case was dismissed, you couldn't get your license back. We actually had a soldier who was due in court the next day, reported to duty, was embargoed, shipped to the Middle East, couldn't get back for 6 months. His license was suspended. He had a legal excuse, but up until Senate Bill 10, I did not even have the discretion to return his license other than essentially being untruthful to the Department of Driver Services, saying issue a 942 form, which means his case was over. It was not. So I do have some wiggle room now, and I'll be honest with you. I lean towards the side of the driver. But here's where the problem arises, and it arises by the score every single day. Somebody missed a court date. They wrote in their computer wrong. Something came up that morning, they were sick. They gave it to their mother, brother, father, whatever to take care of it. Attorneys make mistakes. Now they come to court, and they want to try the case. After all, they're defending a criminal case, especially if they're a commercial driver. They want to win the case. Well, if they don't have a legal excuse and they're not within the discretion, they're not going to get their license back. And if they want a jury trial in Fulton County, and I bind it over to state court, 18 to 24-month delay, because my court doesn't have jury trials anymore. This body abolished that almost a couple of decades ago. So now you have a driver who maybe had a brake light that went out. It's not going on their record, but they still want a trial, to which they're entitled. They ask for a judge trial. When they first see me, it's an arraignment. So I've got to set it off in the future at least 3 or 4 weeks, and it's even worse than that. It used to be somebody came in with an FTA. I want to pay this ticket. I want to see a judge. Go right upstairs. We have such a backlog. My dockets are full. They say, we have your information. We'll mail you a letter when your trial date comes up, and that's 6 more weeks down the road. Meanwhile, this person does not have a driver's license. They can't drive anywhere, not to work, school, church, the doctor. And if they get caught, they get arrested for driving with suspended license. 2 days in jail, $500 fine, and they lose their license again for 6 months. We can already punish an FTA driver by simple contempt. You got served with a summons, you didn't show up, we can put you in jail for 10 days, fine you $500, or both. Typically, it's a $50 late fee. One person went to jail in my court. It was his 8th FTA in a row, and there was just no other way to deal with it. So we already have the power to punish these late folks. This is what gets to me and gets in my craw. Someone, all right, they didn't have a legal excuse. We're all human. They missed a court date. They want to try the case to protect their record, and they're sitting on the fence without a license for 2 years. Or they're faced with a choice. I'm going to enter a guilty plea or a nolo plea, which goes on my record, in order to get my license back. I have a real problem, constitutionally and otherwise, someone having to surrender their right to be presumed innocent just to get their license back, especially when I've got a remedy to deal with contempt anyway. Of all the solutions suggested to deal with this FTA problem, this is by far the best solution. It gives everybody a second chance. Not only that, and I get paid flat rate, so I'm lazy. The less cases I see, the better. Somebody comes into court, I've got an FTA. The clerk says, okay, we're going to set your case down, either right then and there. And the minute they come to court, my clerk sends an electronic message to DDS saying, unsuspend this driver. So that issue that I have to deal with when they finally come to court, it's already dealt with. The only issue is, do you pay a late fee? And the whole angst, I don't have to deal with anymore. And I like giving people a second chance. And this has worked, by the way, with the cell phone legislation Representative Carson did. They come into court, they've wasted a whole morning, and I say, go and use the cell phone properly, go and send no more. And you wasted a whole morning coming down here. You're never going to do that again. You'll remember to use your cell phone properly. We rarely get repeats. That first chance in cell phone has basically worked. Occasionally you'll get a double. This week I actually had a triple, but it's rare. And if it works in the cell phone, giving everybody a second chance, it should work here. In fact, I know it'll work here. And this is absolutely the best solution by far to deal with this problem. Because people absolutely go into tears sitting at the clerk's window. I've seen it. You know, my father died. I had to leave town. There wasn't time to call the court. Even though I'm not supposed to, I'll probably give him a Senate Bill 10 relief anyway. But because there before the grace goes all of us. I practiced 25 years of law. I never missed a court date, but nobody's that good. And they're going to get penalized anyway. And this, what Representative Reeves is offering, I think will solve 98% of the problem. It is a great idea, and it'll make my job a lot easier. And I think all the other judges would probably agree, but I only can speak for myself. And I see this I dread Monday and Tuesday late court session. It's just one agony after another. So I'll be open to questions, but I deal with this all the time.
Thank you, Judge. I don't see any questions. Thank you. Brittany Burns. Brittany Burns. All right. Wade, Askew. Hi.
Good afternoon. Thank you, Madam Chair, members of the committee. I'll be brief. Judge Jackson, who we were very happy to work with a couple years ago on SB 10, articulated it better than I could. But so we at Georgia Justice Project we worked on SB 10 a couple years ago, and we've worked on the implementation of that law. And what this bill would do is really just clear up some of the hiccups in implementation of that law, trying to really give people a path back. I missed court. I'm trying to re-engage the court. Let's get my license back, stay in the workforce, and be able to move forward adjudicating this case in whatever way is appropriate. This bill would really take care of the two most common problems that we see. One is inconsistent application of the current law, where fortunately there are judges like Judge Jackson who are using that current law, but then there are some who are not, who are essentially operating under old law. And this would make for a consistent experience for Georgians throughout the state. And the other is some of these delay issues that Judge Jackson described. So I'm happy to answer questions about kind of the weeds of the bill, if there are any, but it would fill a huge need. And the reason the chambers are in such support is because 80% of Georgians drive to work. 105,000 licenses a year are suspended for this reason. So that's a significant chunk of the workforce that risk losing a job, not being able to get to work for this issue. And this would really give a path for folks who make that kind of one-time mistake to be able to get back on track, get their license, and move forward with the case.
Great. Thank you. No questions.
Thank you.
Coco Guthrie Perry. Is it Perry? Pappy, sorry. All right.
Hi, thank you so much for having me. Chairman and members of the committee, my name is Coco Guthrie Pappy. I'm from Deep Center in Chatham County, Georgia. We are in firm support of this bill. I want to keep it very simple. Deep Center works across a whole spectrum of youth and adults, but we very often work with youth who have parents who are justice impacted and currently court involved. These parents are tax-paying members of the community who this bill will provide direct relief for. Yes, they've made a mistake, but they are doing all the right things that we are asking them to. And by allowing people to keep their driver's licenses during legal proceedings, we are helping support people to secure jobs and occupational licenses. We are empowering them to provide for their families, rebuild their lives, and be accountable in the way that we are asking of them, right? And it's all the more important as courts across the state continue to experience the backlogs. I think Judge Jackson spoke to some of the issues that we certainly are seeing in our community right now, the way that judges' hands are not only tied, but how people often end up in a purgatory in an attempt to do the right thing. And we often see that even more compounded. I think Wade kind of spoke to some of the way that happens, but I think something that we often see that is really unfortunate is someone's license is suspended and they still have to drive, right? Where they need to drive, whether it's childcare or work, whatever it is, they still have to drive. And then there's even harsher penalties, right? This bill is absolutely the right thing. Again, we're offering our firm support for it. And if there's any questions I can answer, I'd be happy to. Thank you.
Thank you. Okay. Representative Byrd?
And it's not, well, directly at you, but just kind of a general, thank you, Madam Chair. So someone has committed some type of crime. They are supposed to show up to the court. They failed to show up for the court, so you pull their license. Is that correct? Okay. So then how are they, so I have to go back to the crime part. So do they have any recourse? I mean, if they've been charged with a crime, are they still having to go in front of a court for whatever they've done?
Yes.
But you are giving back their license even though they failed to show up. Okay, that answers my question.
So essentially, it doesn't relieve them from the criminal offense. It's just not having that automatic license suspension.
And Representative Byrd, here's the key with this bill.
Can you get on the mic?
Here.
Matt?
And what this bill makes clear is the defendant has to engage with the court, and the court has to approve the excuse. It's not automatic on the defendant's part. It gives the judges latitude to control the license process, and instead of getting stuck for months on end with DDS. That's what this bill does, is it gives, if the defendant takes responsibility and convinces the court it was an honest mistake, it gives the court latitude to intervene and get the license back.
Yep. And I want to be sure that you stated that this has nothing to do with like a DUI or drunk driving. Is that
That's right.
correct?
We've taken care to make sure child support, drunk driving stay out of this, and we'll police that. If there's anything that's of concern on that, we will fix that. But that was the intention of this bill. These are low-level offenses that don't have a nexus to driving. Child support, that's kind of the only thing you could do to get child support paid is yank the license, and then with DUI, they don't need to be driving except under certain limited circumstances.
Correct. Thank you.
Thank you.
All right, Chairman Leverett.
Thank you, Madam Chairman. Well, I've got the sponsor just to make sure I understand and to kind of elaborate on Representative Byrd's question. So if I get cited for some traffic offense and fail to appear, my license is suspended, not because of the underlying crime, but because of the failure to show up
That's
when
right.
summoned to court.
That's right.
So your bill will allow me a way to get back into court to contest the charge, correct?
That's right.
Is that right?
Absolutely. And to be diligent, if you say, look, I had COVID, or here's why I didn't show up for that court date, judge, here's the situation, here's my doctor's note, it allows the court to intervene and get the license back without having months on end in the process.
So is it fair to say that you're basically allowing the judge some discretion to accept a justifiable excuse?
Absolutely.
Basically due cause for the absence, for the failure to appear?
We've got that now under Senate Bill 10. This would expand, that basically, if you finally engage.
Judge, I'm sorry, can you get on the mic?
Senate Bill 10 was the excuse bill.
Okay.
This would pretty much make it automatic. You just show up and engage with the court, and you're going to get your license back, and you won't be forced into entering a plea just to get your license back. And it's not just in Atlanta. I saw Vance Smith from Hamilton Pine Mountain. They don't have a state court. If you want a jury trial in a traffic case, a judge from Columbus comes up twice a year. The delay down there is probably longer than it is in Atlanta. And this would basically say, engage with the court, show up, you'll get your license back automatically the first time, and then we'll work it out from there. And we can still give them the late fee, or in the case of the multi-offender, put them in jail for a weekend so they'll never FTA again. And it's pretty much an automatic system. We've got a little discretion now. This basically, like cell phone, gives everybody a second chance. And the stories that you've heard are absolutely true. I see people driving with a suspended license. Well, I'm under an FTA and I have to go to work. How they support their family. My heart goes out to those people. Now I don't have to deal with it because they'll automatically get 1 second chance. And I really think this is just, I don't know of any other way to deal with it. And this does deal with it because they're still going to be punished for being late, and they won't get a third chance.
Chairman, do you have another question?
One quick follow-up. And they also are not going to get an acquittal by doing this. They still have to.
Oh, yes, the underlying
still
traffic
would try
ticket.
the underlying charge, and they'll, whatever happens with that happens with that.
Representative Leverett, you're correct. When I have my FTA calendar, there are actually two cases in one. You missed your court date, what happened? After we answer that question, Then we get to the ticket itself. That's one of the reasons those calendars take 2 and 3 times longer than any other calendar. And you have to hear all the stories. And for those of us who are old enough, it's like Queen for a Day all over again. You may remember that. And the stories are just heart-wrenching. You know, I got to work. I got to take my kids to care. I'm sorry I missed a court date. My kid got sick. It's either come to court or come to the doctor. Well, you can fudge a little bit on Senate Bill 10, but just somebody that forgets, give them a second chance. We know we want to close the case out as quickly as, and in my court, they have to wait to come into court even longer. And that's hard to take.
Thank you, Judge. I understand Ms. Leslie from the Department of Driver Services here. It would be great to hear from you. Hi.
Good afternoon. The seat was kind of low. Sorry. As you stated, I'm Shavonda Leslie with the Georgia Department of Driver Services. I serve as the Director of Governmental Affairs and Communications. We have been working with the author of the bill to ensure that we can provide some assistance, but also to provide some uniformity. And I'm just seeing the substitute, so he's hearing some of this for the first time because I didn't see the sub. So we have some concern a little bit with lines 130, 138, and 143. Currently, as it stands, the clerk of court will send us a notice. And the way it reads here, it says, upon receipt of such driver's license number, in working with the author of the initial bill, there was a little back and forth about when someone goes to court providing us notice. The Department of Driver Service does not need to have the back and forth in reference to every time someone's court date is changed. We just need to know when to suspend and when to reinstate, and we need notification of that. And so that would be my suggestion. And just my quick overview of this bill, where it says on line 130, upon receipt of the such driver's license number, maybe clarify that to make sure that it says notice. And likewise at line 138. And then I believe in my quick reading of 143 kind of reestablishes that we over 900 courts report to us when someone's license needs to be suspended or reinstated. This would give them the okay to do it in any such way they decide to do it. So if they want to call us and say reinstated, we just need some type of documented notice of when we suspend someone's license and when we reinstate their license.
Okay, Chairman Smith.
Would the bill author be okay with getting with the department and figuring out how to fix that real quick?
Absolutely.
Okay.
Those are friendly, and we pulled a lot out, and I'm glad to finish that drill.
Okay, all right. I know the chair, Madam Chair, how many more do we have to testify to the bill?
One more.
One more? Okay, maybe it's the pleasure of the chairwoman.
I'll take any motions at this time, if there is one.
What I was going to suggest, Madam Chair, is after the last individual testifies, maybe just suspend for about 5 minutes for them to get the proposed language.
Oh, I apologize. I thought Representative Reeves already had it, but that's fine. And we'll call our last witness on this this bill, Thomas Weaver.
Next case, Your Honor.
Yes. Different hats.
Well, you never
Thank you.
know. It may come to pass one day. It has for so many others. It's so true. Chairwoman, members of the committee, I registered in favor of the measure out there in the hall, but that was before I saw the substitute version. The Georgia General Assembly makes policy, and I will abide by whatever the General Assembly prescribes to me as a matter of law. It's disheartening. You hear Judge Jackson, you hear the department, you hear others people saying, well, you know, you got to have a driver's license to go to work. The irony in that is that the measure was initially the Second Chance Workforce Act. That's what the measure's entitled, even under the substitute version, but it's been gutted. The meat and potatoes of it are gone. It's kind of hard to get that job if you got that record and an employer won't hire you in the first place. I understand that's not the LC number we're working on. I understand that that's not what's being presented to you, and that's not what you're considering. I have a tremendous amount of respect for the Georgia Sheriff's Association and for Mr. Norris. I was even speaking with him on the phone prior to session this year, as I do almost always. And also for all law enforcement proponent agencies down here, including the Prosecuting Attorney's Council, the Superior Court Judges Council, Police Chiefs Association of Georgia, and others. I understand the headwinds against doing anything like that, but I would ask the committee to consider, maybe beg leave. I hate to be sour grapes, but you know, it would be nice if that were to be included, but I guess I'll take whatever the General Assembly's willing to give. It is a small improvement. Something's better than nothing. It may be maybe it's heartbreaker for some, but it's not to complain, Madam Chair. It's just sharing. Because initially, when I registered for, I want to be clear, I thought we were working off the previous LC number, not the last-minute substitute that was dropped a minute or two prior to the subcommittee hearing today.
All right, thank you. Representative Reeves, you need a little bit?
No, I think we're about there. That's it.
Okay. We'll go ahead and suspend for 5 minutes, and thank you.
You just have somebody else move to make that amendment after he reads it.
Okay. All right. Well, we're still on HB 926. I believe Representative Roberts has a quick question.
Sure. I guess I didn't remember all of that of what was in the original bill. Can you just tell me what the sheriff's issues were with and why that portion is taken out? Because it would have been nice to have people get a second chance on their record too.
Yeah, I don't feel comfortable speaking for them on that. I know they wanted to see some precedent from other states, and the states they looked at that had it, they did not reach that comfort level. I think that was the main part, but I would refer you to Mr. Mike Mitchell with Georgia Sheriff's Association, and would defer to him on the depth of their analysis of it.
But that's why you took it out of the bill.
Yes.
Okay.
Yes. Correct.
Got it.
I think it would help Georgia, but that's for another day.
All right, thank you, Representative. All right, we'll hear from you as far as any changes that you'd like to make to your sub.
Chairwoman Hong, thank you so much for that time to do that. On page 6, starting at line 131, strike such driver's license number and add documented notice as established by DDS procedure. And I'd be glad to give this to anybody in the committee who'd like to make this motion. On line 138, strike again such driver's license number and add documented notice as established by DDS procedure. And then finally on line 144, after the word notify, add by established DDS procedure. And I thank Ms. Leslie for drawing that to our attention.
Yeah, the last one was line 144, is that right?
Correct.
And what are we striking?
Don't strike anything, but after the word notify, add by established DDS procedure.
To notify. Can you repeat that again?
Sure. Absolutely. Line 131, strike such driver's license number and add documented notice as established by DDS procedure. On line 138, strike such driver's license number and add documented notice as established by DDS procedure. And then on line 144, after notify, add by established DDS procedure. And back to the adding back the strikes on lines 22 to 30, that reminded me to acknowledge extensive work on this by Mr. David Morgan, in addition to bringing the municipal courts into the loop, which got Judge Jackson here. So thank you, Mr. Morgan.
So are you, just because there's, so we're saying on line 144 to notify by established Department of Driver Services procedure, the Department of Driver Services of driver's license suspension or reinstatement? It does. It's confusing, so that's why how about just to notify by established procedure the Department of Driver Services of?
Sure.
Or is that okay? Okay. All right.
Well, I don't want to speak for Ms. Leslie.
Okay.
Is that okay? Okay.
Okay, what else?
That's it.
Okay, and I know in the beginning of your testimony, you had told us on page 2.
Right, on page 2, those strike-throughs in lines 22 to 30, just add them back in. Don't strike through those provisions. And that came from the Georgia Sheriff's this morning on 28 through 30, and if we're adding that back in, let's add 22 to 24 in.
All right, thank you. Chairman Smith?
I'm just sitting here thinking, would this be a legislative delegation to the department in this determination? Okay.
No, Mr. Chairman.
Okay, thank you.
Chairman Leverett?
Thank you, Madam Chairman. My only question was, are we proposing to say by DDS procedure in the code itself?
Are you specifically stating DDS? I think we're going to write it out. Is that what you're saying?
Yeah, or we're gonna say Department of
Right, of
Driver
Driver
Services procedure, because I don't think DDS is.
Correct.
Okay.
We're going to
was-
do
I was
Department of Driver
abbreviating.
Services.
I got
Correct.
you. All right, thank you. Just wanted to clarify that.
Okay, thank you.
You know, we went down a rabbit well yesterday, Mr. Chairman, on some amendments. I just can't get that out of my system.
That's right. All right, thank you. Okay, so at this time, I will take any motions. All right, do we have a second? All right, and do we have any amendments? Do we want to?
Discuss, Madam Chairman. I think I can articulate them if you want me to for the record.
I think we have it. I think we're good. So what we had just discussed with Representative Reeves, is everybody okay with not repeating all of that? And so we'll go ahead and take Chairman Leverett's amendment. And do we have a second? All right. So all those in favor of Chairman Leverett's amendment, say aye.
Aye.
Those opposed, same sign. All right, and on the motion to pass HB 926 with the amendments, all those in favor say aye. Those opposed, same sign. Okay, passes.
Thank you so much.
Thank you,
All
Representative.
right, thanks.
And we are adjourned. Thank you.
And